So again, my name is Jeffy Collins of Collins and Kruse Law Office. My business partner is Ren Kruse. We're both of the attorneys here. We're a small firm, but we handle everything you see on your screen. We do estate planning for all ages. So that's your wills, financial powers of attorney, healthcare powers of attorney, living wills, special needs trusts, revocable and irrevocable trusts. We do a lot of Medicaid, VA, and asset protection trusts. We do crisis Medicaid planning. So last minute, someone's going to the nursing home or assisted living. What do? How do we pay for it? We do probate and trust administration, as well as guardianships and mesothelioma claims and limited personal injury claims. So today we're going to talk a little bit about myself. We're going to talk about estate planning 101, veterans aid and attendance benefits, and the Medicaid process. So a little bit about me. I'm originally from Findlay, Ohio, which is a city up in Northwest Ohio. I left there after I graduated high school and went to the Ohio State University and did the ROTC program there. So I was a field artillery officer in the Army for 6 years. Got to live in Germany for 3 years, got to go to the Middle East for a year, and then was actually active duty National Guard here in Ohio. Became an attorney now about 12, 13 years ago. Started my own firm and kind of been off and running ever since. I'm married. We have 3 girls. They're now 14, 11, and 8. We live in the Grandview area. That's where our office is located. We also have an office in Findlay. If you're unable to get out of your home, or maybe you live in assisted living, or you're already in a nursing home or independent living and it's not safe for you to drive or get out, we also can do house calls for people if you give us enough advance notice. And our consultations are always free. So what does that mean? Our free consultation is just that. It's not, we lure you in with a free 15-minute phone call and then tell you I can solve your problems or I can do exactly that, but you have to come in and pay me $500 or sometimes $1,500 is what I've heard for an actual in-person consultation. You get a free in-person consultation, and we'll talk about anything you want to talk about, and we will hopefully solve your problems and get your goals accomplished. So first up, estate planning 101. What do you need to know? You need to know the rules, because the government has rules for you when you're alive, and they have default rules for you after you're gone. So if you don't make your own toolkit, if you don't make your own rule book, it'll default to the government's rules, and a lot of people would like to avoid that. So during your lifetime, while you're alive, what are the documents that you need to create to avoid those default rules? That's the financial power of attorney and healthcare power of attorney. Financial power of attorney is what I consider the most important document out of anyone's estate plan. You nominate someone, you appoint someone, I should say, your agent, to take care of banking, business-related items, anything financially related, sell your house on your behalf if you're unable to do so. Or maybe you simply don't want to. Maybe you are going on a 4-week vacation around the world and it's day 2, you've already long gone from your home and something happens at home with your house or your car or something, and you don't have to turn around and fly back to take care of it. If you have a valid financial power of attorney, your power of attorney could take care of it for you. So it is the most important document. Not all powers of attorney are created equal. A lot of people get the generic ones. That's what most estate planning attorneys give out. They're not bad, but as you age, not all the powers are in there by default. And those powers are listed there in the second set of bullet points: creating or amending an existing trust, creating an irrevocable trust, the power of gifting, the right of the power to apply for government benefits, change beneficiary designations. Those are just some of the powers that are not included, that when we have a crisis on our hands, those are the first things we look for. Okay, someone's going into assisted living, we need to apply for VA government benefits. Is that power in there? Can we create an irrevocable trust to try to preserve some of those assets even at the last minute? If that's not in there, it makes our job more difficult or sometimes impossible to do. Excuse me. Healthcare power of attorney. A lot of the ones that you get at your doctor's office are great. Ours go a little more in depth about what type of care you want and when you don't want it anymore. But as you can see on your screen, the agent, whoever you appoint, makes decisions on what procedures, what doctors to see, includes a HIPAA release with that document. What if you don't have those documents? So what are those default government rules? Well, kind of paints you into a corner called a guardianship. So if you don't have those documents and you get into a car accident or you have a stroke and you're ending up in a nursing home or you're in rehab or the hospital, and your family can't pay your bills because they don't have access to your account, or they can't talk to the doctors because you don't have a valid healthcare power of attorney, what happens? Well, you have to go usually to the local probate court and file for a guardianship. You have to have two doctors agree and write an expert evaluation stating you're unable to manage your own affairs. Then you go in front of a magistrate. You nominate someone to be the guardian of the person that needs help, who's called the ward. The person who's supposed to be the guardian doesn't have to be accepted by the court or the magistrate. They have to pass a criminal background check, a credit check. They may have to post a bond depending on how much assets you have. And they would not get that bond back, their own personal money back, until the guardianship ends. So that it can be quite a burden for most people to do that. There's continuing education requirements every year. You have to report to the court if you want to spend something out of the ordinary, ask permission to spend something. A lot of times they don't like to do any asset preservation. So all this to say, to have your financial power of attorney and healthcare power of attorney, there's no reason not to. And you just don't want to put your family through that. So that was rules when you're alive. As soon as you die, financial power of attorney and healthcare power of attorney are no longer valid. Nobody can use them. And that transitions to your last will and testament. Most people have heard of this. A lot of times people will come to my office and that's the only document they have. They won't have their financial and healthcare power of attorney. They'll only have their last will and testament completed. And on average, most documents that I have come across my desk are at least 20 years old. There's nothing wrong with that, but a lot of times people haven't revisited what they wanted for quite some time, and what the document says and what they remember it saying isn't the same thing. So your last will and testament, you nominate who's in control of that process. That's the person that's called the executor. People who get your stuff are the beneficiaries, and at death, the government process is called probate. All wills go through probate. Probate or wills are just the paperwork. Probate's the process to make sure your people get the stuff that your stuff goes to the people you want it to go to. Sometimes probate can be expedited. I get people all the time saying, my best friend's brother's cousin's son died and they didn't have to go through probate. Well, if they died with a will and assets went through assets would have had to gone through probate. There are ways to avoid probate, which we can talk about here in a little bit. But the probate process it can be lengthy. It can be expensive. As you can see there, right now, I tell people a regular estate that we deal with is usually about 9 to 12 months, minimum of 6 months, because the government, your estate has to be open to give creditors a chance to come after it for at least 6 months from the date of the death. You have to go in front of a magistrate. You have to pay several thousands of dollars or more to an attorney to help your executor to get through the probate process. There are releases from probate. So a lot of times if there's a married couple and one spouse dies and everything's going to the spouse that's still living, the surviving spouse, that could be an expedited process. So it wouldn't take 6 months to a year. Or if it's under a certain dollar amount, there are certain thresholds that the probate court has. If it's under this amount, they'll expedite it. But generally, like I said, the average estate takes 9 to 12 months. And the other bad thing is it's all public information. So you pass away, your executor brings your original will to the attorney's office. We fill out the 10, 12, 15 forms. One of those forms lists all of your assets and how much they're worth at the time of your passing. We submit those forms and eventually they get uploaded to the clerk of court's website. So if you went to the Franklin County Clerk of Court's website and you knew someone that passed away recently, you could look up their probate records and see how much they were worth time of their passing. A lot of people don't like that. I would not like that. It leads to a lot of scams for the surviving family, because now people read these scammers can read the obituary and say, oh, he has a surviving spouse. I'm going to call and pretend to be this granddaughter I read in the obituary and say, hey, can you please, I'm from your bank because I just saw Chase Bank valued at $25,000 or something on that form. So if you can avoid it, I would highly recommend avoiding probate. How do you avoid it? Beneficiary designations. So you can still have a will just to make sure if anything fell through the cracks, it'd be taken care of. But beneficiary designations is one of the most popular ways to avoid probate. And that's how you avoid probate without a trust. But you can see it's transfer on death, payable on death on all of your financial accounts. So what happens is when you pass away, your loved one should only have to go to the bank, probably fill out a bank form and present your death certificate, and then the bank would cut the check to whoever the beneficiary was or beneficiaries were stated. So if it was to my two kids equally, they would cut a check to both kids individually to get their share of your checking, savings, IRA, whatever that might be. You can do transfer on death titles on all of your vehicles. You can do survivorship deeds on real estate, which we highly recommend. Other ways to avoid probate are revocable living trusts and irrevocable trusts. I'm not going to go into too depth here today. I usually recommend people come in for their free consultation to talk about how trust could relate to their very personal situation. We're not a one-stop trust shop. You're not going to get a trust just because you come talk to us or we buy you dinner. Like a lot of popular ways to get trust to people. But the good thing about revocable living trusts are it avoids probate. You're in charge of it. It can be revoked at any time. You put whatever rules you want in there. Sometimes it's hard to put a lot of rules in your last will and testament. With your trust, you can pick whatever rules you want. They have to wait till they're 30. Before they're 30, they can only use it on, education, maintenance, and support. You can stagger it at so much at 25 and then the rest at 30 or 35. We use those a lot, and I'll get into this later again. But for blended families, where I always say the Brady Bunch, Mike and Carol Brady, they pass. If Mike dies first, and Mike and Carol both had a will, all of Mike's stuff and his first spouse's stuff, the boy's mom's stuff, went to Mike. Now all of that goes to Carol. And since they died with wills, Carol's free to rewrite her will after Mike's gone and cut the boys out of their own mom's inheritance and their dad's inheritance and give it all to the girls. So we do a lot of revocable trusts for especially blended families, or if you have properties out of state, since real estate has to be probated where it's located, if it doesn't have a beneficiary designation on that deed. Irrevocable trusts are a little bit more restrictive, or a lot more restrictive, I should say. And those are used for asset preservation from nursing homes, assisted living, memory care, to get on VA benefits, those types of things. So you got to know your pitfalls when you're planning. We've talked about the government. We've talked briefly about the family, but we're going to talk a little bit more about the family now. The government, how is that your pitfall? We talked about the comparison using the default rules that they set forth, which is generally more expensive, as opposed to rules that you make up yourself in your own documents. So your family, how can they be a pitfall for your planning? If your spouse gets remarried, so you pass away, your spouse gets remarried and they change everything to the new spouse's family. Maybe they go on the outs with your own family for whatever reason. We see all kinds of things. If your spouse has long-term care needs while you're still alive, if we planned ahead, we might be able to save even more. What about those kids? If you have a kid that spends $2 if you just give them one, they've been bankrupt a couple times. You can protect people from themselves by setting more rules in your trusts for that. And we've had people set up a trust for their daughter who had an addiction. She was addicted to heroin. She was in her 50s, and the mom had two children, son and a daughter, and was afraid, one of the things keeping her daughter sober was the fact that she was broke and living back at home with her mom while she recovered from her addiction. So she still wanted her daughter to get her money. If she died, she wanted that house to be sold, and they would each get about $100,000, but she didn't want that to trigger, to go into relapse. So she put it in a trust for her daughter. Her daughter could pay bills, pay rent, whatever she needs monthly. She just had to prove her sobriety for a certain length of time. If you have someone that's disabled or becomes disabled, so if you have a relative that might inherit it from you and they're on SSI, SSDI, Social Security Disability, they're on some other government program or some private program that has asset limits. We had someone with Down syndrome. Their grandmother passed away. She left him $75,000. He was about 35 when she died. And he was in a type of Goodwill type house. Where they had he lived on a campus. They had to work, they had education, and they had his apartment all on one campus. Most of the residents there had Down syndrome. He had lived there since he was 18, loved it, had friends, everything. But it was all needs-based. And, as soon as he turned 18, he had the needs-based because he was no under his parents' monetary parameters. But then he inherited all its money, and he had to, unfortunately, move back home for about a year before he qualified again. You can leave people assets, money, if they're on government programs. You just have to do it the right way. Usually it's a special needs trust. Divorce, financial aid for grandkids, you don't want to mess any of that stuff up with your inheritance that you're leaving people. So that's estate planning kind of 101. If you have more individualized questions, feel free to reach out to our contact information, which is at the end of this presentation, and get your free consultation. So what's VA aid and attendance? It's a government program for the veterans. This is what you can get. It's quite a bit of money. It goes up about $50 to $100 per category every year. Surviving spouse of a veteran, if you can see that, the widow of a veteran had to be married to the veteran at the time of their death, so not divorced, and have not remarried since. So if you married a veteran, they passed away, and you got remarried to a non-veteran, you would no longer be eligible for this benefit. If you were married to a veteran and you got divorced, and then 10 years later he died, and now you want to try to get this benefit, you would not be eligible. You have to be married to the veteran at the time of their death, unless you can prove spousal abuse or something like that, and that was the reason why you got a divorce, which we've just done one of those recently, unfortunately. So steps to eligibility, they look at four things: the veteran service record, the veteran's income versus their approved medical expenses, asset limits, and your health. You got to serve at the right time and for at least 90 days, one of those days during a period of war, no dishonorable discharges. Now, for World War II, Korea, and part of Vietnam, you actually did not have to be in the war itself to qualify. So if you're looking at your slide, for example, the Korean War, last day was January 31st, 1955. So let's say your first day on active duty, you're reporting to your unit, was January 31st, 1955, and you're in Fort Knox, Kentucky, or tanker or something like that. And you went on to serve 90 days and got an honorable discharge and all of that, you would be eligible for this benefit, even though you were never in Korea. Now, Vietnam is a little different. In the first part of Vietnam, February 1st, 55 to August of 64, you actually have to be able to prove you were in Vietnam for at least one day, boots on the ground, or on a ship just outside of Vietnam on the coastal waters. Then, though, from August 5th, 64 to May of 1975, it doesn't matter where you were. Again, you could have been in Texas, Germany, Japan, anywhere in the world, as long as you served for those 90 days. And one of those days was during a period of war, that second period of war, you would be good to go. The Gulf War is a little different. It's August of 1990 through today. They haven't ended it yet, but you had to have 2 years of continuous service, not just 90 days. Second, your income has to be canceled out by your medical expenses. What does that mean? If you have $5,000 of income each month coming in, gross income, you have to have $5,000 of approved medical expenses. You have $1,500 of income and $1,500 of medical expenses. Whatever it is has to be canceled out. What is not a medical expense? That's kind of easier to start there. So number 7 on your slide. Personal needs items, prescription drugs, copays, deductibles, doctor's visits, surgeries, therapies. All of those do not count up front for aid and attendance benefits. Our goal at our office is to get you eligible for the full amount for the rest of your life, and you never have to worry about it again. If you can use those items I just mentioned, but you have to do it retroactively. So if we were going to use those items now, we would be looking at your costs that you had in 2024. So then in 2025, let's say we get you eligible based on your 2024 numbers, but then in 2025, your costs went way down because you didn't have another hip surgery this year. At some point, you'd be ineligible. And then at some point in the future, the VA would figure it out and ask for all the money they paid you back, even the money you were actually eligible for. So it's not worth it, in my opinion. So we use the first 6 to get you eligible, and then you never have to worry about it again, which is the cost of home health care. So provided by a third party, maybe have a company coming in helping take care of you, whether you live at home, independent living, or assisted living, or anywhere. Cost of a child caregiver, so a family or a friend or neighbor, anybody but your spouse, you can contract with them, and you would actually have to pay them, and they would come help take care of you. the VA would recognize that as a cost. So for example, if you have $1,500 of income and you hired your son and daughter to come help 20 hours each a week and you pay them the full $1,500, you would be eligible for this benefit. The full rent at assisted living counts, as well as long-term care, which is a nursing home. Your health insurance premiums count. And the big one that a lot of people don't go for, because it's a little bit more of a pain for us, the processors, is independent living rent can count. So if you move to the right type of independent living community, which you can call our office and ask before you move in, if that the VA would recognize it as a correct independent living community to move into. If you combined your rent there with, and you're getting home health care, a third party company, or a family or friend caregiver coming in, the VA will recognize your rent that you pay at independent living to counterbalance your income. So those are the income. We've talked about the service requirements. We've talked about income, and now we're talking about assets. The asset cap is only $159,000. I wish it was higher. I think by the time you get to 159, that money goes pretty fast, even when the VA does kick in. The house is exempt even if transferred. So this is a big one that we see. A lot of people come to our office, say, hey, Dad got sick. He was in the hospital. He got out of rehab. We found him a place. We sold his house. We're ready to try to get VA benefits now. Before he sold his house, he had $50,000 in his bank account, and the house was worth $200,000. So now they sold the house, and now he has $250,000 in his bank account. So obviously he's over the asset limit by quite a bit, and he's probably going to have to wait 3 years before he could try to get VA benefits. Since the house is completely exempt, if you were to put it into a VA trust before it's sold, the transfer is exempt as well. Then the VA would not recognize, they're not supposed to recognize the $200,000 house you just sold. They would only recognize what was in your checking account. So that would make you immediately eligible for VA benefits and help you pay for assisted living or get into a nicer place for a longer period of time. So you also need some health. You need help with at least 2 activities of daily living. So getting up, showering, bathing, going to the bathroom, meal preparation, eating, transportation, going from laying to sitting, sitting to standing. The VA is not as strict as, say, Medicaid is, but you do need to get some help with your health. And that's something we could talk about on an individual basis in your free consultation. Some miscellaneous things, I say it's taking 10 to 12 months, but right now we're discovering it's starting to inch up to 14 months or more. If they recently just fired a lot of people with the VA, so that's probably going to jump up even more, unfortunately. If you don't know where to get your DD-214 or your service record, you would go to the archives.gov, and it's free. So if you find yourself paying for your service record, you're probably getting scammed. You can get it for free at the archives.gov. Our office will do it for you for free too. So if you don't remember and you find yourself somebody asking for your credit card information, just call our office and we'll fill out the form for you. And all you have to do is sign it and we'll get it signed off. So that's VA aid and attendance in a nutshell. We don't have too much more time, but Medicaid. So I don't put a lot on the Medicaid slides. I've gone back and forth to this being 10 more slides, to it being 4 more slides. It's pretty complicated. It's different for everyone, for the most part. So I'll just hit the basics and tell you, if you don't remember anything else, remember this. So Medicaid. Those are the mistakes we see people doing all of the time. They're not getting their own advocate is the biggest mistake. Medicaid is Medicaid's advocate. The nursing home is the nursing home's advocate. The placement company is the placement company's advocate. All of these people are not your personal advocate. You hire us to be your advocate. And if you have that, you'll probably come out cleaner on the other side and not make as many mistakes in the process. So Medicaid has an income limit. It's $2,901. Now, this is a kind of a common misconception. People think, oh, the nursing home said I make $3,000 a month, I'll never be eligible for Medicaid. If you're over that, you just have to jump through some hoops. The only way you can be ineligible for Medicaid because of your income is if you make more than what your cost of care is each month at the nursing home or assisted living or memory care. So for example, if your income is $4,000 a month and the nursing home's $15,000 a month, sure, $4,000 is more than $2,900, but it's not more than the $15,000 nursing home bill. So you would be eligible for Medicaid. You would just have to jump through these hoops, called a qualified income trust, as you can see on your screen. Now, if you're going to, let's say, assisted living and the rent there is $5,500 a month, but you make $6,500 a month, you would not be eligible because you make more than what your cost of care is each month at the assisted living community. But once you are on Medicaid, all of your income goes to that building as a copay, and that's all you would ever pay them for the rest of your life. And you get a $50 allowance each month. That's not much. That's why we do part 2 here. So that's Medicaid income, Medicaid assets. If you don't remember anything else, remember this. If you're married and your spouse is going into a nursing home and it's been the last minute, you've done no planning, it's unexpected, which is where most people are at. We're a big crisis firm. We do 15 or more crisis cases a month. We prefer to pre-plan. That's why I put on these webinars and go talk in public, because pre-planning makes everybody's life easier. But if you don't remember anything else, if you're married and there's still a spouse at home who's healthy, relatively healthy, we can still protect around 90% of your assets, even at the last minute. When you're single, that number drops down to 20 to 50% on the high end, but you can still protect something. We're not protecting millions of dollars for people. Usually we're protecting $20,000 or $30,000 for a single person or less. That way, if you are on Medicaid and you're single, your asset limit, if you can see on the slide, is $2,000. So you're only going to have $2,000 in your bank account, and you're only going to keep $50 for an allowance each month from your income. So if you need anything when you're single, you would have to depend on your family to supplement your income and go buy you whatever you need or give you spending money, especially for assisted living. They have a lot of activities. They go out and do things, and $50 doesn't go a long way. So if we're able to save $10,000, $12,000, $15,000 off to the side, or 20, whatever it might be, your family would have access to that money, but you would not. And if they wanted to, they could give you the spending money from there rather than pulling from their own savings or 401k. When you're married, you can see the asset limits there. But again, even if you see those numbers, we're still able to preserve some more money for the healthy spouse. Again, 95% on average for us is what we can save if someone's going, a married couple, and one of them's going into the nursing home or assisted living at the last minute. There's a spend down. Spend down, again, is optional for married couples because we can almost save it all without the spend down, but you can still spend down if you would like. You can prepay funerals. You can read it all there. I don't want to read it to you, but that's the most common one, is prepay a funeral. If you're married and someone's staying at home, we do a lot of home improvements to make it a little bit more safer, or a little safe. I can't think of the word, like the bars, and making the place more accessible for the healthier spouse if they might need that. Again, it's optional for a married couple. Single, a lot of misconception around the home as well. So how does the home work with Medicaid? We talked about how does it work with VA. The home is completely exempt. You can transfer to a house and sell it, and the VA couldn't do anything about it. Well, if you transfer the house to a trust and sell it, that would be within the last 5 years, because Medicaid's a 5-year look back. That would not be good for Medicaid. When you're healthy, you have a healthy spouse at home, your home is completely exempt. There's some extra hoops you have to jump through after the sick spouse is on Medicaid that a lot of people miss. You have to get that home out of your joint name to just the healthy spouse's name to make it completely exempt. But it is exempt. You don't have to sell it. Anybody telling you, if you're married and there's a spouse staying in the home, anyone telling you have to sell it is wrong. And they're trying to take advantage of you, most likely, or they're just completely incompetent. Single individuals, your home is technically exempt. So, and Medicaid will tell you that it's exempt. Nursing homes will tell you it's exempt. So if you have $2,000 or less to your name and you have a $200,000 home, people will say, well, just apply for Medicaid now, because they want their bills to get paid as soon as possible. They don't want to wait for a home sale. And you can exempt the house, get on the Medicaid, and let's say you're on Medicaid for 3 years before you pass away. You pass away with the house still in your name. Medicaid has a program called Medicaid Estate Recovery. You pass away, your family's going to get a letter from the Ohio Attorney General's office or a subcontractor for the Attorney General's office saying, hey, while your father or mother was alive, the state paid $200,000, $175,000 in benefits for their long-term care. When you sell that house, you have to pay us off first. It's a big shock for people. So what we usually do suggests if you're single and most likely not going to be able to go back home and nobody else in your family is living there or helping take care of you, to use any of the child caregiver exemptions or any of that stuff that might be available, is to sell it as quickly as possible. And we would try to protect that 20 to 50% of that home's value up front, where you'd be able to protect 20 to 50%. The rest of it would go to the assisted living community or nursing home or memory care place that you're going to. Talked about this a little bit ago, but advocate, we're your advocate. We give out free consultations. We usually give out free second consultations to follow up family members. A lot of times we'll talk to one child first and they'll bring the siblings and the parents in if there's an emergency. Or sometimes we just talk to one of the spouses first and then they want to bring the kids in. We'll give you at least 2 to 3 options to choose from, I hope. Sometimes in a crisis case, you might only have one option, but then we do fixed pricing. Our pricing includes everything that we can think of that you would encounter. We don't start low and then nickel and dime you the whole way. We know what a Medicaid application is going to take. If that's what you need, you'll see the fixed price at the top of the form, like option A is this, option B is this, and then it's up to you to decide whether you want to move forward or not. We're not going to make you choose on the spot. We want you to go home and talk about it and then let us know what your decisions are, or have that second consultation and for your follow-up conversation. I appreciate everyone's time tonight. If you have any questions, please call us at that 614-369-8634 number. You can go to our website too and fill out the contact me form. That also is a great way to get a hold of us.